Right, so 5 AB, this is 5C we've covered, now 5D. In 5D, we'll talk about how you discharge a contract by consent or you discharge a contract by breach of the contract and by operation of the law, right? By consent. By consent is sort of when you decided to enter into a contract, there's some terms there, but both parties have agreed that due to certain factors and certain conditions, the terms of the contract will not be sort of in a sense not be fulfilled. So, for instance, when you buy a car, like I said before, you buy a car and the contract was that 5,000 kina for used car, but an important condition of the contract was the car has to be inspected by a mechanic. So you pay 1,000 kina deposit. The buyer pays 1,000 deposit to the seller, and they agree to get a independent mechanic to inspect the car, and the mechanic looks at the car, and the mechanic says that, "I'm sorry to tell you guys this, but there's a very, very serious fault with the engine or the gearbox. It's a fundamental fault, and basically the car is not in a condition to sell." So when these things happen, okay, the buyer will tell the seller, or seller will tell the buyer will tell the seller, "All right, sorry, I cannot buy the car because of the fact that the mechanic, a knowledgeable person, has inspected the car and seen that the car is not in a good condition. As a result, I cannot buy the car from you. So I will ask that you give me my 1,000 kina refund, and we consent to end the contract here." So when this happens, you see, it's by consent or will that they've mutually sort of come together and mutually agreed that the contract must come to an end. So that's what we mean when we say mutual consent of the contract. Right. So when you talk about consent, both parties must agree that the contract has come to an end. All right. Now we talk about the breach of contract. All right. So the breach of contract is what terminates a contract. So, for instance, if in a contract, if I say that I'm going to give you my car and you want to give me $5,000, so in the fact that I give you my car and you have not given me the $5,000 kina, 5,000 kina, you will be in breach of contract. So as a result, I will sue you, and I will get the my cost for the car, which is 5,000, and any additional cost that I may have incurred. For instance, lawyer's cost, trying to go around and get documentations, all the costs that I've incurred as a result of you not paying me 5,000, I will get for the breach of contract. So breach of contract will basically, you can claim damages, and that is for the money to be paid back and all the costs incurred to be reimbursed. So whenever a party that has breached a contract is liable to pay for damages. So basically, if you breach a contract, you are the party that is liable to pay for the costs. All right. By operation of the law, this means that some contracts are void from the beginning. So classical contracts that I'm talking about are contracts void or made illegal by statute. So in this case, for instance, if you're a construction company and the secretary for works says that I have a contract of 2 million, and basically signs an agreement with you for the 2 million contract. But then after, let's say, the minister or a government or the opposition looks at the contract and say that, "Hey, wait a minute, the secretary under the Public Finance Management Act as a Section 32 officer does not have the financial powers to award a 2 million contract. Its only financial powers is to award a 1 million contract. 1 million and above, the contract must go to the National Procurement Commission to tender the contract and for the contract to be allocated." So, as an instance, all of the contract has been made by operation of the law, by virtue of that law, that's the Public Finance Management Act, which gives certain officers in the public service and the ministry and the commission, the national procurement, as well as the central tenders and suppliers board, it gives them some financial limits. So when you go when you sort of act contrary or over your financial limit, you will see that you will be liable for the contract to be terminated by operation of the law. So when this type of things happen, you will see that the contract is terminated. There was not any contract from the beginning, so parties are restored to the original position. But however, let's say that you've given a 2 million contract load and you have already performed work for 500,000. So in order for you, although the contract is void, but it's the operation of what you call quantum merit. So there's a law of equity called quantum merit where the court will say, the law says that you get paid for what you have done. So although the contract is void, you worked for, performed work for 500,000 kina, you must prove evidence that you have incurred, a cost like that. And then the government will reimburse you, pay you 500,000 kina, because although the contract was void by operation of the law, because the secretary did not have the financial powers under the law to grant a contract of that value, uh, basically what will happen is that the contract will be void, and you will be, because you have done work, you'll be compensated for the work. If you have not done work or anything else or incurred any costs, the contract will be void from the beginning. Thank you.